excessive, excessive, use of force by staff. Excessive or unnecessary force by police or prison staff violates the Constitution and may be remedied by damages or injunctive relief. In serious cases, the officers or supervisors may be criminally prosecuted. Prisoners, too, are sometimes criminally prosecuted and convicted in connection with use of force incidents, which may limit their ability to seek relief in subsequent lawsuits. The constitutional standards. The precise constitutional standard applicable to a use of force claim depends on whether the plaintiff is a convict, a pretrial detainee, or an arrestee at the time force is used, though it is open to question how different the standards really are in practice. Convicts. Convicted prisoners are protected from misuse of force by the Cruel and Unusual Punishment Clause of the Eighth Amendment. The Supreme Court has held that whenever prison officials stand accused of using excessive physical force in violation of the Cruel and Unusual Punishments Clause, the court judicial inquiry is whether force was applied in a good faith effort to maintain or restore discipline, or maliciously and sadistically to cause harm. In deciding whether force was used maliciously or sadistically, the extent of injury inflicted is one factor, and the absence of serious injury is therefore relevant to the Eighth Amendment inquiry, but does not end it. Other factors that the court said may be relevant are the need for application of force, the relationship between that need and the amount of force used, the threat reasonably perceived by the responsible officials, efforts made to temper the severity of a forceful response. The malicious and sadistic standard applies to the actions of staff who are directly using force. The deliberate indifference standard staff who are directly using force. The deliberate indifference standard applies to staff members who stand by and do not intervene in an illegal beating and to claims of inadequate policy, supervision, training, or control by supervisors or local government. Pretrial detainees. Detainees are protected against excessive force. Pretrial detainees. Detainees are protected against excessive force by the Due Process Clause of the 14th Amendment, or for federal detainees, the 5th Amendment. The standard governing detainees' use of force claims is not settled. For many years, most courts followed the Second Circuit's decision in Johnson v. Glick, which held, not every push or pull or shove violates a prisoner's constitutional rights. A court must look to such factors as the need for the application of force, the relationship between the need and the amount of force that was used, the extent of injury inflicted, and whether force was applied in a good faith effort to maintain or restore discipline, or maliciously and sadistically for the very purpose of causing harm. These factors were also cited in the Supreme Court's Hudson v. McMillan decision discussed in the previous section concerning convicts' Eighth Amendment claims. The difference is that in Hudson, all the other factors are weighed only to decide whether force was used maliciously and sadistically, but under Johnson v. Glick, all of them, including malicious and sadistic intent, are given equal status. Some courts have continued to use the Johnson v. Glick standard. However, since Hudson v. McMillan was decided, several federal courts have applied its malicious and sadistic standards to detainees under the Due Process Clause, as well to convicts under the Eighth Amendment. Others have tried to apply the Bell v. Wolfish detainee conditions and confinement standard to use of force cases, or have devised other standards. One circuit has said generally that detainees' use of force claims are governed by the Fourth Amendment standard of objective reasonableness, probably refers only to persons who have not yet been arraigned, arrestees, and others seized by the police. Police use of force is almost always analyzed under the Fourth Amendment reasonableness standard, which governs all claims that law enforcement officers have used excessive force, deadly or not, in the course of an arrest, investigatory stop, or other seizure of a free citizen. Investigatory stop or other seizure of a free citizen. Under the Fourth Amendment, you need not show malicious intent because the officer's state of mind is not important. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them without regard to their underlying intent. First, the Supreme Court has held that it may only be used against a fleeing suspect where the officer has probable cause to believe that the suspect poses a threat of serious physical harm either to the officer or to others. The courts do not agree about when a person ceases to be an arrestee protected by the Fourth Amendment. Some courts say the Fourth Amendment applies until the arrestee receives a probable cause determination in court, or as long as she remains in the custody of the arresting officers, or some combination. Police does not involve any sort of seizure. The Due Process Clause protects persons against excessive force. Applying the standards. It is open to question persons against excessive force. Applying the standards. It is open to question how different these standards really are in practice. Whether you are arguing that force was objectively reasonable in a Fourth Amendment case or used maliciously and sadistically in an Eighth Amendment case, you must usually show that it was not justified by any legitimate law enforcement or prison management need or was completely out of proportion to that need. Issues that frequently arise in use of force cases of all types. 1. Amount of force. There is no fixed line for how much force violates the Constitution. It depends on all the circumstances. When prison officials maliciously and sadistically use force to cause harm, contemporary standards of decency are always violated, unless the force is de minimis, which means minimal. But even de minimis force may be unconstitutional if it is repugnant to the conscience of mankind. If there is no need for force, the Constitution may be violated by relatively small amounts, even a push or a shove. However, serious and even deadly force does not violate the Constitution if the necessity for force is serious enough and the officers did not intend to cause needless harm. Even when there is need to use some force, the use of force completely excessive to the circumstance always violates the Constitution. Conversely, any efforts made to temper the severity of a forceful response will weigh against a finding of liability. Injury. Prisoners need not prove a serious or significant injury to establish excessive force. In Eighth Amendment cases, the degree of injury is relevant to the inquiry, but does not end it. And nothing in the Fourth Amendment concept of an unreasonable seizure requires physical injury. It simply requires unreasonableness. As for pretrial detainees, officials are forbidden to inflict any punishment, not just injurious punishment, on them. The extent of injury is therefore but one of the factors to be considered. Even if the injuries suffered were not permanent or severe, a plaintiff may still recover if the force was unreasonable and excessive. Many courts have upheld constitutional use of force claims in which no physical injury was alleged, although most such cases involve a serious threat of injury or death, or other extreme circumstances. Courts have also held that force used during interrogation when the suspect poses no threat is excessive, regardless of injury. Courts recognize that mental pain can be as real and as serious as physical pain. Although, under the Prison Litigation Reform Act, you cannot recover compensatory damages for such injury unless you have also suffered physical injury. Despite these principles, defendants, and I can stop injury unless you have also suffered physical injury. Despite these principles, defendants, and I can stop right here, like on that note right there. And you know, I school for psychology too, you know what I'm saying? So it's like on a psychological, but we're gonna go beyond psychology, we're gonna go into the neurosciences, okay? When we talk about the neurosciences, you got the neurology, you got the neurobiology, which is psychiatry, you know what I'm saying? You got psychology, you know what I'm saying? But you got, now, if on a your body produces all of these endorphins, these serotonin, your body produces all of these endorphins, the serotonin, all of that, right? For and then if someone chemically balanced, right, get on like medications, okay, well, if you have physical pain on the one hand, you have a mental is when you look at the definition of pain. Pain is pain, period. Now, on a physical level where you can see it, you can hit me in my arm and make it bruise, right? Okay, well, but yet, now, I'm just going to say, if you call me a B word, just for instance, I ain't trying to cuss like that on here, you know what I'm saying? But if you call me a, you know what I'm saying, a B, now it might hurt me deep down inside on an emotional level, as if you just smacked me across my face. But you can see it as you smack me across my face, I got a red mark. But you can't see this internal pain. But it's one and the same. It's pain. And on a physiological level, from a neurological level, in the way the brain functions, and it creates its chemistry and biology, and then the endorphins, serotonin, etc., etc., etc. You know what I'm saying? Within, it's out of whack. You're chemically imbalanced. You know, and that's where we psychologically, because of the way our brain functions on a neurological level, for how it defects on a neurobiological level, we have to be the better person. And you cuss me out, and I just walk away or say God bless you. You know what I'm saying? Something like that. It can affect us, and that's why some people have to have medications. But pain is still pain, regardless. So you might be able to see that physical pain, but you can't feel that emotional trauma, mental pain, as in PTSD. For and it's Memorial Day, or you know what I'm saying. So, how many people have went overseas and fought in Afghanistan and stuff, and are messed up in the head? Or how many people under a circumstance like this may be incarcerated, and they're messed up, and the pain that they feel is real. You see what I'm saying? You just can't see it, and they mask it with the smile on their face. You see what I'm saying? And that's where that's where when it comes to law and that's where that's where when it comes to law and I got too much on my case to emotional, mental, physiological, when they look that neurologists, psychiatrists, everything have that those are chemicals in the brain going throughout your body, and that makes you up and down, happy. You see, and so it's still physiological, even if it's mental. It's what I'm saying. So pain is pain. They say it's what I'm saying. So pain is pain. They say I'm a real. Courts recognize that mental pain can be as real and serious as physical pain. Though under the Prison Litigation Reform Act, you cannot recover compensatory damage. This same realization that I have, that what I'm saying, it's gonna be what it's gonna be. But despite these principles, defendants frequently argue that force cases should be dismissed because the injury, as opposed to the force, was de minimis, and sometimes the court accepts the argument. However, the Supreme Court strongly rejected the idea that de minimis injury de minimis force and force are only imperfectly correlated. It is the latter that ultimately counts. Inmate who is gratuitously beaten by guards does not lose his ability to pursue an excessive force claim merely because he has the good fortune to escape without serious. As a practical matter, even when courts analyze the issue directly, infliction of minor injuries such as bruises and abrasions will be found constitutional only if there was no need to use force at all, or if there is evidence of malicious or sadistic behavior by the defendants. If you physically resisting authority in some way, or injury or minor, the defendants were responding to a major The defendants were responding to a major threat to safety or security. Infliction of or life-threatening injury, injury to prisoners where there are sworn allegations or other evidence of serious injury. So what that's saying is summary judgment. And if you know anything about the law, you know what I'm saying. Then, like in civil cases, you know what I'm saying, is when you get into your discovery, either you, the plaintiff, file a motion for summary judgment, and the motion for summary judgment, what it's saying is that you're trying to summarize the whole case, that this is what happened, and you're requesting judgment in your favor. And so what you have to do pursuant to the rules of let me go get that book. Check this out. So now we're going to speak on summary judgment for a minute. Rule 50, I think it's 56, it might be 57, I forget right off my bat. It's let's see. Rule 50. Let's see. All right. Rule 56. And it's on page, I don't know. I have to find it. Rule 56. Rule 56. Here we go. Rule 56. Here we go. All right. Summary judgment. A motion for summary judgment or partial summary judgment. A party may move for summary judgment identifying each claim or defense, or the part of each claim or defense on which summary judgment is sought. The court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. The court should state on the record the reasons for granting or denying the motion. Time to file a motion. Unless a different time is set by local rule or the other court orders otherwise, a party may file a motion for summary judgment at any time until 30 days after the close of all discovery. Which it's only a little bit longer, but then after they lose on their summary judgment, as that's what we was talking about, then they either try to settle, mediate, you know what I'm saying, a claim, or you go on to trial. But I'm going to go on further because it's just a little bit more on this, and then we'll get back on where we was talking about. But that's what you understand about what I was talking about when I was talking about what I just read, and it had to do with summary judgment. Procedures. Supporting factual positions. A party asserting that a fact cannot be or is genuinely disputed must support the assertion by citing to particular parts of materials in the record, including depositions, documents, electronically stored information, affidavits, or declarations, stipulations, including those made for purposes of the motion only, admissions, interrogatories, answers, or other materials, or showing that the materials cited do not establish the absence or presence of a genuine dispute, or that an adverse party cannot produce admissible evidence to support the fact. So basically what you're doing is, and when they file that motion for summary judgment, what you got to do is you got to dispute all the facts that make a claim unconstitutional, and you got to show and prove it with exhibits. Or if you file that summary judgment motion, that's what they got to do to you. And then ultimately, you know what I'm saying, that's how they you got to dispute the facts, basically argue the law and give your evidence. And so it's so that's how they do it, and they decide whether there's factual disputes in violation of the Constitution and it merits a trial, or if they're going to dismiss your case or whatever, you know what I'm saying? So that's just how that goes. And then either you lose your case and you have to appeal if you want to appeal, or you can settle, or you go to trial, you know what I'm saying, if you win. Anyways, objection that a fact is not supported by admissible evidence. A party may object that the material cited to support or dispute a fact cannot be presented in a form that would be inadmissible in evidence. And I'm gonna give y'all something right here. Y'all may not know this. Y'all might, you know what I'm saying? But, police departments, places like that, even if you're in prison or something like that, you can have a cop, you know what I'm saying? For instance, internal affairs can do polygraph tests, CVSA, computer voice stress analysis, lie detector tests. But I'm going to tell y'all this, though, straight up. Man, that is not proven science. It's just a physiological response to you during questions, and a person is going off their opinion as to what that physiological response means. There's no evidence to support it. So therefore, lie detectors and tests like that are inadmissible in court. But if I was to see you right now and I were to hit you and I gave you a lie detector test and I can show that you failed it, right? And I use that as evidence on my behalf. If you don't dispute it and tell the court straight up in your opposition motion, you see what I'm saying? That's inadmissible, and you motion in limine. That's what it's called in civil cases, motion in limine. But in like a criminal case, it would be a motion to suppress, and that's to eliminate the evidence. You got to do that, or then it could be entered into the court. You know what I'm saying, and utilized as evidence, and that's solely because you had the right to dispute it and you didn't and object. And it's just like if you're at trial, you know what I'm saying? And then this is the thing. If you're at trial, like on a criminal suit, a criminal case, every time, you know what I'm saying, there's something your lawyer needs to object to, they need to be like, objection, Your Honor, and briefly state the case. You see what I'm saying? And if they don't do that, now you get your appeal, say you're in prison now, right? I'm just saying, and you don't have your attorney anymore, and then you get a new attorney, and they look at it and was like, dude should have objected right here, dude, or she should have objected right here. Your lawyer didn't do anything. Then that's when you can file like a Rule 37.1 in Arkansas, which is it's what do you call that? We call it a Rule 37. It's a petition. Man, I forget what it's called. What's it called? I can't even think of it right now. But look, it's a Rule 37.1. But you have to file under Strickland versus Washington in a criminal case for ineffective assistance of counsel. Okay, and that would be your only appeal there. On that note right there, and then maybe you can appeal further because yeah, they should have objected and they didn't. So like if I were to sue you, you know what I'm saying, and then I file your lie detector test showing that you're lying and you don't object to it, then it can be admitted as evidence. But if you object to it, or if I object to yours, you see what I'm saying? Then the court's gonna throw it out because it's an inadmissible evidence. It's not, lie detectors are inadmissible unless you don't dispute it if somebody tries to admit it, and that's that. But anyways, materials not cited the court need consider only the cited materials, but it may consider other materials in the record, affidavits or declarations. But I've really pretty much summarized summary judgment for y'all. You know what I'm saying? So now we're gonna go back to right here where we was at, so I can finish this. Courts may not grant summary judgment based on prison medical records that minimize injury to prisoners, where there are sworn allegations or other evidence of more serious injury. Meaning that them prison guards, they ain't gonna win. You know what I'm saying? They not gonna get summary judgment. It's gonna go to trial. They're gonna have to settle out if the person want to settle out with them. You know what I'm saying? Yeah. Anyways, 3, malice. In Fourth Amendment cases, you need not show that the officers acted with malicious intent. And once again, for all of y'all, if y'all haven't been following along, if you're a pretrial detainee, you're not to be punished, number one, and there's certain things that they have to do under to maintain security, you know what I'm saying? But if a police uses excessive force against you, it's not an Eighth Amendment violation, it's a Fourth Amendment violation, okay? And it's all about the objective reasonableness, you know what I'm saying? And there was no reasonableness to amount of force used, and it's a Fourth Amendment violation, not Eighth. But if you've been sentenced to prison, you're in prison, then it becomes an Eighth Amendment violation, and then you got to prove malicious and sadistic intent to cause you harm. Okay, so once again, malice. In Fourth Amendment cases, you need not show that the officer acted with malicious intent. By contrast, in Eighth Amendment cases, whether force was applied in a good faith effort to maintain or restore discipline, or maliciously and sadistically cause harm is the primary question. Once again, I said that a little fast. In Fourth Amendment cases, you need not show that the officers acted with malicious intent. By contrast, in Eighth Amendment cases, whether force was applied in a good faith effort to maintain or restore discipline, or maliciously and sadistically to cause harm, is the primary question. In pretrial detainees cases, some courts require a showing of malice, and some do not. To establish malice, you need not be able to prove directly what was in the officer's mind. Malice is generally inferred from the officer's actions and the circumstances in which they take place. If staff act maliciously and sadistically, they can be held liable if the person they injured was not the person against whom their malice was directed. Justifications for use of force. Force may be used to restore or maintain order in a jail or prison, not to punish prisoners or to retaliate against them. Keeping order does not mean that once a prisoner has misbehaved, anything goes. Force that is unnecessary or excessive to the need may still be unconstitutional. As a practical matter, it will be harder for you to win such a case, since prison officials will argue that your misbehavior justified their actions. Many courts show very little patience with misbehaving prisoners. Now, I'm going to stop right here for another quick second. See, that's the whole facade that these cops and people be using. Oh, we're the good guys. We're the good guys. Yeah, protect and serve. That's what we do. You know what I'm saying? And yet they're going around killing people, beating people up, and then go scrimmage to the courts. Oh, we're the good guy. Oh, no, they did this, so we're justified. And now you're not. You know what I'm saying? And then, like they say, I'm going to read it again. As a practical matter, it will be harder for you to win such a case, since prison officials will argue that your misbehavior justified their actions. Many courts show very little patience with misbehaving prisoners. And any court, any officer, anybody that does that is dead wrong. And that just goes to show that they're criminals, but yet they're the system. You know what I'm saying? It's sad, but this is the legal way. This is the legitimate way to fight them. You arm yourself with the knowledge of the law, and you stand. You know what I'm saying? But it's all legal. You know what I'm saying? That's why I study this law. You know what I'm saying? For real, and it's also psychological. Just saying. However, if officers use substantial force after you had stopped or been stopped from whatever you were doing, or when you were restrained or locked in a cell, their actions may still be unconstitutional. If that is what happened to you, you should make that fact clear in your complaint and other litigation papers. The same principles apply if force was used to control a prison disturbance. The legal standard is the same in disturbance cases as in other forces cases under the Eighth Amendment. But in practice, courts will give prison officials more leeway when they are faced with a riot, a takeover of a housing area, or any other serious loss of control. Well, this will be true in cases involving arrestees and detainees as well as convicts. However, even in a disturbance, prison officials are not entitled to do anything they want to prisoners. They still have to present some justification for their actions. They may not rely on a disturbance that was already over when the force was used, nor can they get your case dismissed simply by invoking the word disturbance. If there is a factual dispute whether force was used against you in quelling a disturbance, prison officials are not entitled to summary judgment, and a court or jury may rule in your favor after a trial. Physical abuse may not be used to extract information from prisoners, even when the information is related to institutional security. Types of force. Weapons. The use of weapons by prison and jail staff and police is generally assessed by the same standards as others' use of force. The use of firearms in case of prison disturbances has been upheld, though it will not necessarily be valid in all circumstances. The use of stun devices will not necessarily be valid in all circumstances. The use of stun devices has been upheld where they are used to restore order, but held unconstitutional where their use has been clearly excessive to the need used to restore order, but held unconstitutional where their use has been clearly excessive to the need. Courts have acknowledged that requiring prisoners in court to wear stun belts, which administer a severe shock when activated, can deter criminal defendants from participating in their own defense and conferring with their attorneys, and have held that their use must be limited. similarly to the limits on the use of restraints in court. The unjustified use of water hoses and fire extinguishers against prisoners has been condemned by several courts. And let's see. I know one it's an 8th Circuit right there. See, they got a few my state cases up in here that was like revolutionary for my state, you know what I'm saying? And you know, in this book, you know what I'm saying, you got all these annotations down here. So it goes straight to numbers on the sides and lets you know what number it is. And you come down here at the bottom, it's blocked off, and you got numbers right here, and you got all of these cases in short. And then you can go look them up, you can read them, study them, find them, you know what I'm saying? And that's what you use in your defense too, you know what I'm saying? But the chemical agents. The use of chemical agents, too, is governed by the same standards as other uses of force. It is usually upheld when prison staff are attempting to restore order or subdue recalcitrant, including in some case persons in restraints or locked in their cells. However, the unnecessary use of tear gas or other chemical agents has been held unlawful by a number of courts. Officers may not use chemical agents against a person who poses no risk, or continue to use chemical agents on a person who has been secured or has stopped resisting. Once chemical agents have been used, prisoners who has been secured or has stopped resisting. Once chemical agents have been used, prisoners, including bystanders who have been exposed, must be allowed a reasonable opportunity for decontamination. Restraints. Prison officials may use restraints for security purposes, but the courts have curbed some extreme or abusive restraint practices. For example, in Hope v. Pelzer, the Supreme Court held that the Alabama hitching post practice, in which prisoners who were accused of refusing to work were handcuffed for long periods to a horizontal bar exposed to the sun and without access to drinking water or toilets, violated the Eighth Amendment. The court emphasized that the practice was painful, humiliating, and dangerous, and that it was clearly intended as punishment for past conduct and not to ensure safety. In Hope versus Pelzer, the court held that prison officials had been deliberately indifferent to the risk of harm to prisoners, but it did not say whether all restraint cases are supposed to be decided under the deliberate indifference standard. In fact, courts have taken several different approaches. Some have treated restraints as the form of use of force and have applied the Hudson versus McMillian malicious and sadistic standard that governs other prisoner use of force claims. Some years ago, the Supreme Court held that liberty from bodily restraint always has been recognized as the core of the liberty protected by the Due Process Clause from arbitrary government action, and that this interest survives criminal conviction and incarceration as well as civil commitment. Some courts have applied the Youngberg due process standard to prisoners. Some have asked whether incidents or practices of restraint meet the Stanek versus Connor atypical and significant hardship test, and they have come up with different answers. Others have applied different due process theories, mostly in cases involving pretrial detainees. Restraint issues in arrest or search cases are governed by the Fourth Amendment's requirement of reasonable searches and seizures. Since the courts have not agreed on the right legal theory in restraint cases, the best course for a convict or detainee may be just to plead them all. Deliberate indifference, malicious and sadistic intent, deprivation of the right of bodily liberty, and atypical and significant hardship. And be sure you make the facts clear in your complaint, since there are some clear fact-based patterns in the way courts have decided restraint cases. The most important factor appears to be whether there is a plausible safety reason for the restraints. Courts have generally upheld the use of restraints on segregation or other high-security inmates when they are out of their cells, or in some cases, their cells where they have committed serious misconduct. Prisoners may generally be restrained when they are out of the prison and there is a danger of escape. However, even in that context, excessive and indiscriminate restraint practices may be struck down. Prisoners who are actively disruptive may be restrained, including by placement in a restraint chair or 4 or 5 point restraints. Prolonged restraint may be lawful if the prisoner is seriously disruptive and if the prisoner receives food, water, bathroom breaks, and medical attention. However, the use of restraints may be unlawful if they are applied in a manner that is dangerous, painful, or injurious, degrading, done for a punitive or retaliatory purpose, or continued for longer than safety requires. Handcuffing may be unconstitutional if it inflicts injury because the cuffs are excessively tight or for other reasons. Handcuffing prisoners to stationary objects has been found unconstitutional. The use of black box restraints over handcuffs during transportation has generally been upheld. Hog tying, securing a handcuffed person's ankles to the handcuffs, has been found unconstitutional in some circumstances. Failure to supervise and protect persons in handcuffs may be unlawful if injury results. The Supreme Court has held that non-prisoners may be detained for safety reasons in handcuffs during the course of a search, even if the search takes hours. State statutes or regulations may restrict the use of physical restraints. These restrictions may be enforceable in state court. The use of restraints in federal prisons is governed by regulation. Sexual abuse by staff. And yeah, it's going to be all right. Sexual abuse of prisoners by staff can violate the Constitution. This rule is not limited to correctional staff, but also applies to other staff who have been authority over prisoners or access to them because of their positions. It applies regardless of the gender of the abuser or the victim. To establish an Eighth Amendment violation, prisoners must show that prison staff have a sufficiently wanton state of mind. Since there is no legitimate purpose for sexual abuse, the behavior itself is generally enough to show wantonness. It is not completely settled how serious the sexual misconduct must be to be unconstitutional. One federal appeals court held that sexual abuse can violate the Eighth Amendment if it is severe or repetitive, but others omitted the severe or repetitive limit, and it may be obsolete. A more recent district court decision held that contemporary standards of decency have now evolved to the point that any sexual assault of a prisoner by a prison employee constitutes cruel and unusual punishment. Under any version of the standard, any form of actual sexual penetration is likely to be unconstitutional. Sexual harassment that does not involve physical contact generally is not unconstitutional. Courts have disagreed over the status of less intrusive actions. The Fourth Amendment probably provides a more favorable standard for arrestees than the Eighth Amendment standard for convicts. One court has held in a Fourth Amendment case that unreasonable, non-consensual, inappropriate touching and propositioning is unlawful and that there is no situation that would justify any amount of purposeful sexual, verbal, and physical predation against the handcuffed arrestee. A prisoner need not show physical injury to pursue a claim for sexual abuse by staff. It is not clear whether sexual abuse by itself satisfies the Prison Litigation Reform Act's requirement that prisoners show physical injury in order to recover compensatory damages for mental or emotional injury. And see, that's what I was talking about earlier, and how I was showing you with the neurosciences and all of that's crazy. But yet this goes right here, and it says that, let me read it again. It is not clear whether sexual abuse by itself satisfies the Prison Litigation Reform Act's requirement that prisons show physical injury in order to recover compensatory damages for mental or emotional. So there's a conflict there, and there's a question mark that it's not even clear. You know what I'm saying? And that, that's another thing that, hopefully nobody has to go through this stuff. You know what I'm saying? But, it happens, I guess, in prison or whatever. And if, it should be argued. You know what I'm saying? Courts have disagreed whether a prisoner's consent or submission to staff sexual misconduct is a defense for the staff member in a civil rights suit. One federal appeals court has held that a prisoner who voluntarily engages in sexual activity is not subjected to the infliction of pain that is a necessary element of an Eighth Amendment claim. Other courts have emphasized that in most states where sex between prisoners and prison staff is unlawful, it is impossible for a prisoner validly to consent to sex, or have said that circumstances of imprisonment mean that prisoners' consent is not voluntary. Sexual abuse claims may be asserted against supervisors or against municipalities on the same basis as other supervisory or municipal liability claims. One court has held that when an officer presents a known risk of sexual assault, a collective bargaining agreement with a prison staff union cannot serve as an excuse for doing nothing about that person. The Prison Rape Elimination Act of 2003, otherwise known as PREA, directs the U.S. Attorney General to promulgate national standards for the detection, prevention, reduction, and punishment of prison rape by staff as well as by other prisoners. Prisoners who have been sexually abused may need medical attention or psychological counseling. Claims that such care was denied are governed by the same deliberate indifference standard applied to other medical and mental health care claims. Sexual abuse may constitute the torts of assault and battery or an intentional infliction of emotional distress, also known as outrage, or it may support a claim of negligence by supervisors, any of which may be actionable under the Federal Tort Claims Act as well as directly under state law. Now, let me show y'all, say this to y'all though. The Federal Tort Claims Act, that's only for federal prisoners. So if you're not in the feds, then, but now that's why it went on to say as well as directly under state law, because all a tort is just like a small claim type. It's a violation of state law that doesn't amount to a United States constitutional violation, and therefore the courts can't do nothing for you that in the federal court. I mean, unless you can file with your complaint to like consolidate them all in one case, and for them to decide the merits of both. This by federal and this by state. You see what I'm saying? All in one. And if they choose to, then you can do it like that. But otherwise, you'd have to take your tort claims straight to, state court. Or if you're in the feds, you can use the Federal Tort Claims Act, which is the Federal Tort Claims Commission. You know what I'm saying? But it may be hard to recover for staff sexual abuse against the abuser's employer based on respondeat superior. The tort rule, which means that the employer often pays for the employee's misconduct. That rule usually applies only when the employee's conduct was within the scope of employment, and sexually abusing prisoners is not generally within prison employee's scope of employment. However, if the employer itself was negligent in some fashion, it can be liable without the need for a respondeat superior argument. Verbal abuse. Verbal abuse. Most courts hold that verbal abuse by itself does not violate the Constitution. That holding includes racial epithets and other racial abuse. However, verbal threats of force may be unconstitutional in extreme cases, usually involving plausible threats of death or injury, or where they are in retaliation for constitutionally protected conduct. Verbal abuse may be an aggravating factor where physical abuse is also established. And it may help prove malicious intent or unreasonableness of the force used. Verbal abuse that subjects a prisoner to attack by other prisoners may violate the Constitution. Under some circumstances, certain kinds of verbal abuse can constitute the tort of defamation, which is addressed in another chapter. Liability for force. Bystanders, supervisors, and municipalities. Law enforcement officers may be held liable not only for using excessive force, but for failing to intervene when others are doing so. This principle, first asserted in police cases, applies equally in prisons and jail and to line staff as well as supervisors. Under this rule, you may be able to recover from all the guards involved in a beating, even if you don't know which ones actually struck you or who struck which blows. So, I don't know if I should, I'll go ahead and finish that one up. All right. Then I'll get into the juice. Claims against bystanders are decided under the deliberate indifference standard, rather than the malicious and sadistic standard that applies to persons actually using force. However, the bystanders must have had a realistic opportunity to prevent or stop the beating in order to be held liable. Supervisory officials who were not even present at the bidding may sometimes be held liable if you can show that their actions or inactions, such as failure to act against officers with records of misusing force, led to excessive force against you. Several courts have found police supervisors liable for misuse of force by officers based on histories of inadequate training or inadequate investigation of citizen complaints. City or county governments can be held liable if you can show that the beating was caused by a municipal. City or county governments can be held liable if you can show that the beating was caused by a municipal policy of failing adequately to train and supervise staff and investigate use of force complaints. Maintaining or tolerating a code of silence about staff misconduct can support complaints. Maintaining or tolerating a code of silence about staff misconduct can support supervisory or municipal liability. Claims of supervisory or municipal and sadistic standard was adopted is that decisions concerning use of force are often made in haste. And sadistic standard was adopted is that decisions concerning use of force are often made in haste, under pressure, and frequently without the luxury of a second chance. The failure to train or to discipline officers to investigate complaints or to have an appropriate written use of force policy generally involve long-term practices and not split-second decisions. Claims based on such policies or practices are similar to prison conditions and confinement cases in which the prisoner need only prove deliberate indifference. So that's what I was going to read tonight. But what I'm going to go back to real quick to summarize a few key points, okay? Number one, if you're pre-trial detainee, if you've not been convicted of a crime, go sit to prison. If you're not in prison, you've not been convicted. It's about conviction. If you've been convicted, even if you're still in the county jail, now you're convict. If you're still facing charges, you're considered a pre-trial detainee. So when the police utilize excessive force against you, if they do, which hopefully and they never do, but just saying, or anybody else, you know what I'm saying? If you're awaiting charges, then the standard. If you're convicted, it's an Eighth Amendment, cruel and unusual punishment, and you have to prove that they was maliciously and sadistically for the sole purpose of causing you harm and they cause you harm. However, now this is where I was just at the ending of that, when it talks about anybody that, say there was 4 officers present, 2 officers beat the hell out of you, right? But the other 2 officers that were present, and they didn't do nothing, but they was there, they seen it. They failed to intervene. They failed to protect you, and in return, they were deliberately indifferent. And so you could throw all 3 of those claims up in there, but it's all basically the one claim of deliberate indifference. And it's failure to intervene, failure to protect, deliberately indifference. What deliberate indifference means is that they knew of a substantial risk of serious injury, and they failed to respond reasonably. And that's all you got to prove deliberate indifference. They seen these other 2. They didn't do anything. They failed to intervene. They failed to protect you. They were deliberately indifferent. So you can't get them for excessive force. They didn't use it. You get them for deliberate indifference. Then it went on to say about respondent superior, you know what I'm saying, and municipality. Well, I'm gonna stop right here, and I'm gonna say this. It would be a lot easier. I mean, now, if you got the policies that you can show and prove, or you got evidence that show and prove that they're, just overlooking stuff and they're not, like, trying to punish nobody, you know what I'm saying, their own or whatever, just overlooking stuff and they're not, like, trying to punish nobody, you know what I'm saying, their own or whatever, then that might be something that you can use in your, you know what I'm saying, in your benefit. But it would be a lot easier to sue a supervisor than a municipality. The supervisor above them, they wasn't there, but then they had direct knowledge of this, and they've been knowing this going on, and you got evidence to support this, or, once again, with a policy, and that could be an unwritten policy. You know what I'm saying? It'd be a lot easier because the municipalities is like a city government or a town or something like that, and for instance, is a little bit different, bigger than that, you know what I'm saying? But for instance, and they have this sovereign immunity. That's the 11th Amendment claim. They and then you have state law that can ratify it and everything. But where I'm from, no. If you know what I'm saying, you will have to show and prove that they have policies or there's practices that's going on, they're felonies, you know what I'm saying, that needs to change, that amounts to unconstitutionality, you know what I'm saying? And that right there is really a lot harder. I'm just gonna say that. But if you got that, it's possible. But if you don't, then yeah, they're gonna win by sovereign immunity. But not to dissuade anybody on anything. I'm doing this to try to educate you, enlighten you. You know what I'm saying? Peace.